Mr. Chairman, H.R. 4848, the so-called Censorship Accountability Act, would create a new cause of action for a person to sue a federal employee who, acting under color of federal law, violates that person's First Amendment rights. This bill appears to be based on 42 U.S.C. Section 1983, as Mr. Bishop just said, a longstanding statute that provides a cause of action against state and local officials for the deprivation of constitutional and other federal legal rights. In principle, this legislation could have been a worthy starting point for the committee to consider meaningful reform of constitutional tort litigation. There's a real need for a statutory cause of action to allow people whose constitutional rights were violated by a federal official to seek redress. So far, the primary remedy available to such victims of constitutional violations is a judicially created one under the Bivens Doctrine, a remedy that was limited only to a few types of constitutional violations to begin with, and which has been narrowed so significantly by the Supreme Court in recent years that it is now basically on life support. Unfortunately, I cannot support this legislation in its current form, and I do not think that my concerns can be entirely addressed through an amendment. First, and perhaps foremost, it is unclear why the bill is limited in the scope to rights secured by the First Amendment, when a person's interest in remedying violations of other constitutional rights is equally strong. Additionally, and somewhat paradoxically, by referring to rights, quote, secured by the First Amendment, unquote, the bill may be broader than its draft is intended, as the First Amendment, of course, is not limited to the right to free speech, but includes other rights, like the right to the free exercise of religion. It's unclear whether this was an intentional or drafting error. If it was intentional, I again raise the question of why we should limit this remedy only to the bundle of rights secured by the First Amendment. If it was unintentional, this is an indication the bill was not carefully crafted. Relatedly, the bill's exception for lawsuits brought by federal employees against their employers or the federal government may be too broad. For example, given that the bill otherwise authorizes lawsuits for violation of rights, quote, secured by the First Amendment, unquote, this exception could be read to undermine federal employees' ability to vindicate their religious free speech, free exercise rights against the employee's federal employer. Since the bill does not expressly state that other existing remedies for religious free exercise claims by federal employees, such as those available under Title VII of the Civil Rights Act of 1964, remain, its effect on these remedies is unclear. While the foregoing issues might be addressed through an amendment, I also have deeper conceptual concerns about the bill that would require a total redrafting to fix. For example, by copying much of Section 1983's operative language, the bill would import all the federal case law interpreting the statute, and much of that case law is problematic for plaintiffs seeking to vindicate their rights. While looking to Section 1983 might be a good starting point, by replicating much of its structure and language, we may also end up reproducing, perhaps unintentionally, its limitations. There are many examples of the federal courts interpreting Section 1983's language in ways that limit the ability of plaintiffs to recover damages for constitutional violations by state and local officials. For example, following the landmark 1961 case of Monroe versus Pape, in which the Supreme Court revived Section 1983 as an important civil rights law, the court articulated the affirmative defense of qualified immunity, an entirely judicially constructed doctrine that has evolved into a significant hurdle to Section 1983 litigation. Is it the intention of the legislation's authors to permit federal employees to assert qualified immunity as a defense in a potential action under this statute as well? A more fundamental question is whether this proposal would permit an individual to sue federal employees in their official capacity and to waive the federal government's sovereign immunity for monetary damages. In Will versus Department of State Police, the Supreme Court held that Congress did not waive sovereign immunity in Section 1983 for the purpose of money damage suits against state officials in their official capacity and their state employer. Based on this bill's text, that appears to be the author's intention under this bill with respect to the federal government, as it contains no explicit waiver of the federal government's sovereign immunity. Section 1A states only the federal employee is, quote, liable to the party injured in an action at law, suit in equity, or other proposed or other proper proceeding for redress, close quote. And is defined in the bill, the term federal employee notably does not include the federal government itself, only individuals who hold positions in the government. If the bill's purpose is to hold the government accountable for so-called censorship, why would Congress permit suits against individual federal employees for money damages but not against the federal government itself, even though hypothetically the employee is carrying out the duties of his or her federal employer. Indeed, in advance of this markup, we received a letter from the American Federation of Government Employees opposing H.R. 4848 because, quote, it would penalize ordinary working Americans for simply doing their jobs, unquote, or, quote, in other words, executing their lawful responsibilities in accordance with supervisory instructions, unquote, of their federal employer. Yet notably, the bill exempts from the definition of federal employee the president and vice president, the two officials in the executive branch most responsible for setting policy and executing the law. Thus, under this bill, ordinary federal employees may be personally liable for following their federal employer's instructions, while the federal government and the two officials who might be most responsible for an alleged First Amendment violation are exempt from the bill. What sense does this make? Unfortunately, we've had no opportunity to consider the merits of this legislation at a hearing, including the chance to hear from constitutional law and civil litigation experts to help members assess the bill. Had the committee done so, we might have identified or addressed these concerns. Additionally, at a hearing, we might have explored other legislative alternatives to the bill before us today, such as amending the Federal Tort Claims Act to permit suits against the federal government for constitutional violations. The committee's consideration of this legislation today is a missed opportunity. If the majority were serious about enacting a statute to provide a cause of action for victims of constitutional violations committed by federal officials, we will be happy to work with them on such an effort. Sadly, rather than using this opportunity to actually legislate, we are wasting the committee's time on yet another political stunt. This legislation is based on the false premise that officials in the Biden administration have colluded with technology companies to suppress conservative viewpoints on social media platforms. But more than a year's worth of hearings and investigations by committee Republicans has revealed no evidence of such collusion. Although I support the principle behind this bill, its sloppy drafting invites too many unanswered questions, and to potentially improve the bill may require a wholesale redrafting of it. I would urge members to oppose this legislation so that we can go back to the drawing board and work together on a bipartisan basis to develop meaningful reform on this question. Thank you, and I yield.